have joined. Chris, I'm assuming CN is you. Maybe you can give me some cue for me, for me to be sure.
Yes, I'm in the meeting.
Oh, wonderful. Okay, great. Okay, perfect. Then let's begin. Okay, so hi everyone. I informed you earlier on that today we'll be having a virtual class, and one of the major reasons is that we are privileged enough. We've been very lucky enough to have a senior colleague of mine join us all the way from Lagos to take us on one of the subjects that we have for under company law 2. For the past few weeks, we've been dealing a lot with directors, the different categories, what it means to be a director, duties of directors, powers they have and their limitations, and so on and so forth. It's about time we moved on to something, somewhat also related to that. And that also has to do with, the protection of minorities within the corporate space. And that is illegality and oppression. And if I recall, in the past few weeks, or last week particularly, when you tried to brief, or when you briefed the cases and you were sharing your briefs with us, you realized that for most of them, there were aspects of the holdings of the cases that had to do with illegality and oppression. So today we are going to have some we're going to have our exposition on that subject. And to do that with us is, like I've already mentioned, a senior colleague of mine. Sorry about any, there's a call that keep coming through. So Chris is joining us from Nigeria. He's, like I said, he has been lecturing for so many years. His areas, if I'm not mistaken, company law, international trade and investment, and a host of other other areas.
You are the
Chris, if
professor
you
of
can hear
company
me,
law,
thank you so much. If you can hear me, thank you so much. This is my Bachelor of Laws level 200 post first degree law class here at UPSA. We did the first semester of company law some months ago somewhere. We finished somewhere in December. And this time around, we are doing company law 2, like you are already aware. So Chris, this is my class, a very wonderful class. That is our guest lecturer for today, Mr. Dr. Chris Yinevi. Okay, Chris, over to you. I'll be right here.
All right. Thank you very much, Gertrude, for the kind introduction. Although I must quickly put a caveat that you are the professor of company law, not me. so yeah, I'll do my best to take you through the class. But if there are any tough questions, we'll have to go back to Gertrude, who is the authority on this area of law. Right. So I'm happy to discuss with you today a topic which is important and considered by variously considered by academics in different lights. Whether you have to talk about the remedy against oppression and illegality. There's also a different way to put it, like maybe majority and minority rule in a company and all the power contentions that come with it. So basically, that is what we are going to look at, how the law addresses the power structure within a company, right? Because like any other institution, a company is, a group of people or entities that have come together under one umbrella to do business. And so there are various interests at stake, financial interests, personal interests of people at stake. There are people who are in charge of the affairs of the company. They may want to use the company for purposes that are sometimes at variance with the objects of the company, and therefore to pursue their own personal interests. And sometimes in that situation, it also affects the interest of people who may not be at the helm of the company, those who may not be either the directors or majority shareholders. So their interests may be affected. So how does the law tries to sort of mediates all these interests within the company. So that's what this discussion is about. So I'll begin. Unfortunately, I don't have a PowerPoint presentation. So I'll just be talking and I'll go through some points. I'll try and go step by step so that you can follow it. But Gertrude has some materials, including an article I wrote some years ago with one of my colleagues. I'm sure she has already shared that with you. So I'll be going through that. And then if you have any questions, you can ask, or you can type it in the chat function, and then I will try as much as possible to answer your questions. Now, so first, I'll try and give you a bit of a background to the discussion we are going to have, this whole power dynamics within a company, and how the common law, which is what we inherited, dealt with it. And then we would come to the Ghanaian position and look at how our Companies Act and various cases have also dealt with this issue. So like I mentioned earlier on, like any form of governance system, corporate governance also has its own issues when it comes to the balance of power. So I'm sure if you have been following events in Ghana, in the parliament, you have the majority and the minority side, and then there's issues, there's e-levy and they are fighting over it, and blows are being exchanged and those sort of things. The majority wants to have their way, minority wants to have their say. So that's the kind of thing, similar thing going on here in the company. So in a company, you would have majority shareholders. So maybe 2 or 3 people own like maybe 30% each of the shares of the company. Another person owns maybe about 30%, 25%, another person owns about 5%. So the people who own like 30% each are the controlling shareholders. So they own about 60% of the company, and they probably appoint majority of the directors, etc. So they are very much in charge. So almost every time, what they decide is what becomes the decision of the company, either in general meeting or through the directors they have appointed. So that could happen. And so for that reason, the majority, the people in majority, either in the general meeting or on the board of directors, could use a company for various things, maybe approve transactions which minority members of the company, those who have lower shareholding, do not agree with, or maybe they may even try to sell their properties to the company, or try to sell company properties to themselves, or any of those issues that would normally come up, some conflict of interest and all that. So that's what would normally happen. Then the minority would try to kick against those things, you know, at either general meetings, or sometimes if they don't succeed at the general meeting to be able to defeat those resolutions or decisions, they may want to go to the court to seek the assistance of the court to stop what they perceive to be wrongful actions, irregular actions, or oppressive actions that affects their interests or the company's interest. Now, when it comes to the common law, where all of these rules that we were talking about developed before they were brought to Ghana, and we have also adopted them. Now, the common law English courts adopted what is known as a laissez-faire approach to corporate governance. Now, so the courts did not want to interfere too much in business decision-making. And that is for good reason, because the courts had an idea that they wouldn't want to, if you are in a company, and a company is like an association, you have come together to do business, and principally the decisions of the company are taken by majority rule. That's democracy. So if you're able to persuade your colleagues or your colleague shareholders to agree with you, then that's fine. If you are not able to persuade them, then why should you come to the court crying that the court will reverse a decision that has been taken by the majority, right? So because that will be overturning a majority decision. So the courts don't want to do that. And number two, the court also thinks that, well, I mean, some of these things are business judgments that are exercised, let's say, by the board of directors, that we think this transaction is good, we have to enter into it, this contract, we have to sign it, blah, blah, blah. So the court doesn't want to substitute its judgment of how to run the company for that, or the directors. It thinks that the directors are in charge of the company, and so they may be be in a better position to appreciate what is going on. And so if they want to take this decision, and some people disagree with it, then they should deal with it at the boardroom. Why do you come to the court for the court to overturn a decision that has been taken by the board of directors? So that, like, the business judgment rule also informs this. So generally, the courts, in the English courts, try to take what is known as a laissez-faire approach. So leave the company, let them do their business. If there's some trouble in there, they can use their own internal processes to handle it. If a member disagrees with a decision, they can call a meeting, let them discuss it. If they take a vote and his side wins, fine. If it doesn't win, then, too bad, but that's democracy. And then also, we don't want to be taking over all the companies and associations in the country and be the ones to be substituting our wisdom for the wisdom of the directors who have been appointed to run the business, because sometimes the court itself the judge may not have expertise in that area of business. So why should the court be the one to step in and decide those things? So under English law, the courts took a laissez-faire approach, right, to this. And that laissez-faire approach became exemplified in a case known as Foss and Harbottle. So we'll go a bit into Foss and Harbottle and look at what happened in that case and what did the court decide and how did it influence the development of this area of law about remedies for oppression or majority and minority rule within a company. Now, so let's look at the case Foss and Harbottle. Now, so in the Foss and Harbottle case, the company at the center of the controversy was a company known as Victoria Park Company. And it was a company that was established to buy a piece of land in Manchester, build houses interspersed with lawns and gardens for leasing, right? So that was the idea. So they're basically, like a real estate company that was formed to build, in those days, what may be called as apartment buildings or whatever, luxury buildings and for leasing. Now, so there were two persons, Richard Foss and Edward Turton, who were minority shareholders of the company, right? So Foss and Turton were minority shareholders of the company. And then they sued the directors of the company, including one guy known as Thomas Harbottle, right? So Foss and Turton sued directors of the company, including Thomas Harbottle. Now, their complaint was that those directors of the company were selling their land to the company at an inflated price, right? So I've already told you that the business of the company was to buy land, build housing, intersperse, sort of a luxury building or estate, interspersed with lawns for leasing. Now, so the company needs to get the land to do so. And then these directors of the company had land and they wanted to sell it to the company at an inflated price, right? A price above the market price or what they would ordinarily have obtained for the land if they were selling it to somebody else on the market. So they were selling it above the market price or as an inflated price so that they will get secret profits or secret profits to themselves. Now, so then Richard Foss and Edward Turton go to court and they complain about this, that this is what the directors of the company want to do or are trying to use the company to do by selling their land to the company at an inflated price. So the court should intervene and stop the transaction. Now, the court decided that, I think somebody has their microphone on. If you can turn off your microphone so that we don't have background noises. So the court then decided that no, we cannot intervene. And the court decided not to intervene for two reasons. And those reasons, those two grounds on which the court decided not to intervene have become known as the rules in Foss and Harbottle. And let's go to those two reasons why the court did not intervene. Now, so the first ground on which the court decided not to intervene it flows from the rule in Solomon and Solomon. I'm sure you're familiar with Solomon and Solomon. We say that when a company is established, it acquires a separate legal personality. It exists on its own, independent of its shareholders, and conducts its own business through its directors. So because of this separate personality principle, the court said that if a shareholder or a member of the company alleges that a wrong has been done to the company, because the company is a separate legal entity by itself, then the proper person, right, the proper plaintiff to institute an action to seek redress for the wrong done to the company is the company itself. So because if you're a shareholder, it doesn't mean that you are the company. You just own shares in the company, but you are not the company. In law, the company exists independently of you, the shareholder. So what the court said was that, okay, I've heard you. You are complaining about this transaction which the directors want to enter into, and you are claiming that they are trying to defraud the company and sell the land to the company at an inflated price. But the wrong you are complaining about is a wrong being done to the company, right? So because of the principle in Solomon and Solomon, separate legal personality, if there is any person who has a cause of action or standing, who is a proper plaintiff to sue in this matter, it has to be the company itself, not you, the shareholder. So that's the first ground on which the court said it could not intervene in the case brought by Foss against Harbottle. Then the second reason was that the court said, well, like I mentioned to you earlier on, in the corporate governance, it's majority rule, right? So I have bought, if I buy shares in a company and I have money and I buy a lot of shares, I expect to have more say in the company. If you don't have money and you have bought some 5% shares, why do you want to have the same voting rights as me, right? So the court says, well, you may be complaining about this action because you are minority shareholders, but for all you know, all the other shareholders are fine with the transaction that has been entered into by the company. So why should the court overturn it? Probably against the wishes of the majority of the company. So the court said, well, in this case, if you have any problem with what has been done, then the proper avenue is for you to go to the company, have a general meeting, and if the matter can be resolved or regularized, if you say this is an irregular transaction or travaris or whatever, if the matter can be rectified through the internal procedures of the company, either the company will take a decision and say, okay, we ratify what the directors have done, or we do not ratify, so the directors have to withdraw or back out of the transaction. Then that is their own business. So that you have to go to the general meeting and then decide it at that level. You don't come to us for us to make a decision, which may very well be against the wishes of majority of the company, right? Because if you decide to subscribe to the company, the regulations or buy shares in the company, you have to be willing to abide by the majority decision in the company. So that's what the court said. So we can't intervene. So that's what the court said. So first, the court said a wrong against the company, in a wrong against the company, the proper plaintiff to sue is the company itself. And in a suit brought by a company, or in every decision that has to be taken by a company, including litigation, there's a board of directors who have to decide that, because there's a board that acts on behalf of the company. So it means that if you are claiming that there's a wrong done against the company, it is a board of directors who have to bring the action. If they decide not to bring the action, you as a shareholder, you cannot do that because you are not the company. The company acts through its board of directors, and they have to decide to bring the action. Number two, the majority rule, right? So first is the proper plaintiff rule, and the second is the majority rule. That if there's a wrong that can be remedied through the company's own internal procedures, through a general meeting, etc., then it's for the company to address. The court will not intervene. So those are the two rules that were formulated in Foss and Harbottle. One, the proper plaintiff rule, and two, the majority rule. Any questions up to this point? Let me check the chat and see if there's any question. Okay, there is no question. So everybody understands the discussion up to this point? Okay.
Yes, please.
All right. You're very smart students. Okay, let's continue. Right. So like I said, Foss and Harbottle has two rules. First, the proper plaintiff rule, which says that if there is a matter that someone claims, a member of the company claims, is a wrong done to the company, the proper person to sue is, the proper plaintiff to sue is the company itself, acting through its board of directors. Number two, if the wrong is one which can be rectified or remedied through the internal processes of the company by passing an ordinary resolution, then the court will not intervene. The matter has to be dealt with at the level of the company itself. All right, so those are the two rules. Now, so those are the rules in Foss and Harbottle. But you realize that if you apply those two rules to its limits, it will cause injustice, right? Because like I told you, the majority within the company will normally be people who have the greater voting powers in the company, right? And if you have greater voting powers, normally you would have a greater say in the appointment of directors. So the majority, if you hold, let's say, two people hold 30% shares each in the company, and the constitution of the company stipulates that maybe there should be 5 directors, those two people may have a greater say in appointing majority of the directors. So maybe they may be entitled to appoint about 2 directors each, and the other person, or maybe with their combined strength, they can appoint 3 directors, or at least 3 directors, and then the other person may appoint maybe 2 directors. So if the majority would always sort of have the power, the voting power, either in the general meeting of the company or on the board, because then they would have a majority of the board members appointed by them. So either way, whether in the general meeting or in the boardroom, they may have their way. And if you are always going to allow the majority to have their way, either in the boardroom or in the general meeting, then it means that the board of directors may do whatever they want, like, engage in conflict of interest, sell things, their own personal assets to the company, use company information for their own private gain, use company property for their own personal benefits, etc. So those things may go on. So you cannot say that, well, we have to follow the rules in Foss and Harbottle and never intervene at all, because if you do so, then it's going to cause hardship, right? So because of that, the common law itself tried to mitigate the hardships that may be caused by the rule in Foss and Harbottle, right? So there were exceptions that were developed subsequently to the Foss and Harbottle rule, and there's about 4 of them, 4 exceptions. First exception is that the act complained of, if the act complained of is illegal or ultra vires the company, right? So illegal or ultra vires acts. Then number 2, if the matter is one that may only be validly done or sanctioned by a special resolution of a special majority of the members. 3, if the personal or individual rights of a plaintiff has been affected or invaded. And 4, if what has been done amounts to a fraud on the minority of the company by the wrongdoers who are in control of the company. So 4 exceptions. 1, the act complained of is illegal or ultra vires the company. 2, the matter complained of is something that can only be done by a special majority of the company. 3, personal or individual rights of the plaintiff or shareholder is affected. And 4, that what has been done amounts to a fraud on the minority or of the company. So let's take it one by one. So what it means, therefore, is that the rule in Foss and Harbottle, either the proper plaintiff rule or the majority rule, will not apply in these cases if the plaintiff, the minority shareholder who are sued, is able to bring himself or herself under any of these exceptions, right? So one, illegal or ultra-virus act. So under the common law developed the exception that the rule in Foss and Harbottle will not apply if the directors of the company engage in acts that were ultra-virus. So you know that under the old Companies Act, for instance, the Act 179, there was the capacity of the company was clearly stated. So if the company exceeds its powers, shareholders can bring an action to prohibit any transaction that executive transactions that may have been entered into that are beyond the powers of the company. Section 18 and 19 of the current act have modified it a bit. I think the act only states now that if the constitution of the company, provides a limitation on the powers of the company, then that limitation will apply. Otherwise, the company may engage in acts ordinarily that may exceed its stated objects or exceed its stated powers. So there has been a bit of modification, but generally the principle is that if the conduct or the transaction engaged in by the board or the majority of the company is one that is ultra-virus, that is beyond the powers, because when you establish a company, you have to state the objects, what the company is, the business the company is going to do. Although, like I mentioned, now under the Companies Act, there's a bit of laxity in that the rules have been modified a bit. So the company may decide to state its business and restrict in the constitution what the board may be able to do or not do, or decide to do otherwise. But where there's that restriction, where the company has stated clearly its objects and limited the powers of the board as to what they can do and what they cannot do, then if an act is done that is ultra-virus, that is beyond the stated powers or objects of the company, then a minority member can bring an action to stop it. So then you can't say that, well, it's a majority rule, we can go into the general meeting and rectify it. Because if the action is ultra-virus, you are not even, you don't even have the powers to engage in it in the first place, right? Because you don't have the power to have done so. So you cannot claim that you can rectify it through a resolution of the company, because that is something that the company is prohibited from doing to begin with. You get it? Or if the transaction is legal, it's a transaction which by law is legal, you cannot engage in it, then you cannot claim that it's something that you can regularize through your own internal procedure, right? So either ultra-virus or illegal acts. You cannot, if the transaction is either illegal or ultra-virus, then the Foss and Harbottle rules will not apply. And so the court will hear the matter and determine it, and probably prohibits the company from engaging in such a transaction. Is that clear? Any question on that? Okay, so that's one of the exceptions that the common law developed. Now, the second exception that the common law developed was the matters requiring special majority. Oh, somebody has a question. Kobina.
All right, thank you. Please, can you hear me?
Yes, I can.
Okay. So you mentioned the member who feels that the directors have acted ultra-virus or illegal can bring an action. Would that be through the general membership meeting, or have to be through the court process?
We are talking about court action to challenge it. Because
yes, you mentioned. You mentioned that then the affected minority member could take an action. So I'm wondering what action could be taken within what forum?
Right. So what I'm saying is that, okay, So if an action is taken that is ultra virus or illegal, of course, the first point of contact could be the general meeting, where the company could reverse the action taken, right? But obviously, we are talking about a situation where the majority have taken a decision and they do not want, which probably is in their own interest, so they do not want to change it, right? So that's the kind of situation we're looking at. If the majority is willing, if the matter is brought to the attention of the company and they are willing to reverse the transaction and back out of it, then the problem is resolved. Then there's no issue. But if they are not willing to do so and the person has to go to court, that is where the Foss and Harbottle rules will come in, because we said that the courts said in Foss and Harbottle that, number one, if you engage in a transaction, if a transaction is done which you claim to have injured the company, the proper person to sue is the company itself. So one, as a shareholder, minority shareholder, you don't have standing to come to the court to litigate a matter which for which the company itself is the proper plaintiff. Number two, the court will not intervene if the matter is one that can be regularized through the internal procedures of the company. So if the company can pass a resolution to remedy it, then the court will not hear you. But if a decision is taken that is illegal, right, it's plainly against the law, or is ultra vires the powers of the company, that is beyond the powers of the company, then ordinarily it's not something that's, properly speaking, the company can affirm. So in regularizing an irregular or illegal ultra vires action, what is going on? Or let me put it differently: in regularizing a wrong that has been done, what would happen is there are one of two ways. So the company can decide that despite the fact that this action was irregular, they will go ahead and affirm it, so ratify it, and then indemnify the directors from any liability, right? But if the decision that was taken is an illegal decision, the company cannot purport to affirm that, right? It cannot purport to affirm that. So that's where a member may go to court and ask the court to nullify the transaction, right? So that is the kind of situation we are looking at. I don't know whether your question is answered.
Yes, yes, very clear to me. Thank you.
All right. So any other question? Okay, then let's go to the second exception. The second exception is matters requiring special majority. So there are certain matters that may require a special majority. So what we are saying is that if the matter is one, an irregularity that has been done, and it can be regularized, either by passing a resolution to affirm it, or or withdrawing the decision, then there's no problem. But if the decision that has been taken was one that required a special majority to take it, but yes, still the majority members have taken it without that special procedure or majority, then the affected or the minority member can come to the court to challenge it. So there's a case of Edwards and Halliwell. In that case, what happened was that the plaintiffs were members of an association of vehicle builders. And the rules of the association said that if you wanted to increase the dues of the association, that increase would only be effective if the membership, 75% of the membership, or let me just say two-thirds may not necessarily be 75%, I think about 3/4. So 2/3 of the members of the association vote in favor of the increase in the dues. The executives of the association took a decision to increase the membership dues without recourse to this procedure of submitting it for approval by 2/3 of the members of the association. So the aggrieved members went to court, and the court upheld their claim and said that the ruling Foss about Harbottle did not prevent the individual member to sue if the matter they are complaining about is something that can only be done or sanctioned not by a simple majority of the members of the company, but only by a special majority, right? So if the matter is one that an ordinary majority of the company, simple majority 50 plus one, can decide on, and so they are competent to decide on it, then the rule was that, the common law rule was that you cannot come to court to complain about it. Go to the general meeting and let them handle it. But if the matter is one that requires a special majority, and then a simple majority of the members have taken a decision to go ahead to do it without obtaining the special majority, then a minority member can go to court and challenge it, right? So that is that exception. Everybody clear on that? Okay, let's move on to the second exception, the third one. The fraud on the minority exception. So the fraud on the minority exception is considered to be the true exception to the rules in the rule in Foss and Harbottle. So the fraud on minority exception is where the people in charge of the company, the directors, are taking decisions and entering into transactions that are injurious to the interest of the company, basically committing fraud and dissipating the assets of the company, right? So they're like the instance in Foss and Harbottle, which I told you about. The people are selling their own land to the company at an inflated price, right? And then you want to complain that is a wrong done to the company, but that wrong is not one that can be remedied, because the people who are supposed to take action are the same people in charge, right? So I've told you that under the proper plaintiff rule, the proper plaintiff is the company, but the company acts through the board of directors. So if majority of the board of directors, who are supported by, let's say, majority of the shareholders, have taken a decision, entered into transactions that are injurious to the interest of the company, are selling company property to themselves, or selling their own property to the company at inflated prices, and entering into all sorts of transactions for their own personal interest, you don't expect that those same people who are in charge of the company will go to courts and go and challenge those actions that they are benefiting from. It's not going to happen. You get it? So that's what we call the fraud on the minority exception, where they are using the company for their own personal gain and effectively committing a fraud on the minority. Because if you tell the minority, if you say the company itself should go and sue, it is those people who would have to go and sue, but they are not going to sue and go and have the courts pronounce liabilities upon themselves, right? So they will not do it. So that's one of the exceptions where the court will intervene, right, and say that we will disregard the Foss and Harbottle rules, either the proper plaintiff or the majority rule, and deal with the action if there is a fraud on the minority. So there's a case of Atwood and Merriweather, where the company was incorporated with the objective to acquire some mines, and then some directors of the company sold some mines to the company. And then by that deal, the directors were going to make profits of £4,000 and £3,000 respectively, in addition to the shares allotted to them as consideration for the sale. Now, because the shares they had in the company gave them the power to defeat a resolution to rescind the deal, the court was a view that the fraud on the minority exception had been made out. So the people in this case, the Atwood and Merriweather, let me type it. Atwood, Merriweather. That's the title of the case. Now, so the directors, two directors, they had majority shareholding. So if any decision has to be taken in the company, they can have their way. And then they had gone to make a deal to sell some mines to the company. And each of them was also going to make a kickback, right, from the deal, secret profits from the deal. So one of them was going to get £4,000, another was going to get £3,000. But if you were going to raise the issue at the board meeting, they were going to overrule you because they had majority shareholding, right? So in that case, the court said that the fraud on the minority exception has been made out, and so the court will intervene. Because if the court were to say that the shareholder should go and deal with the matter internally and get rid of the transaction, it will be impossible to do so. They can't set aside the transaction because the people who sold the mines to the company have majority shareholding, so they will defeat the resolution to set aside the transaction. So in that case, the court said it was a proper case for it to intervene, because otherwise, if it did not intervene, a fraud would have been committed on the minority of the company. Somebody has a question. Somebody's asking a question about simple majority. That's simple majority is a simple majority. Simple majority means if you have at least 50% of the people who are supposed to entitled to vote at the meeting taking a decision. Like is your question answered? Who asked the question? Florence. That's a simple majority. A simple majority means you have like anything above half, then you have a simple majority. But a special majority means that we are not just looking at a simple majority, we are looking at a certain pegged threshold that is way above that, like 2/3 or 3/4 of. So for instance, in Parliament, decisions of Parliament are taken by a simple majority, by the majority of members present and voting. But then there are certain matters where the Constitution requires that there be a special majority. So if you have to remove the Speaker, for instance, in voting for the Speaker of Parliament, you require simple majority, right? That's why the NDC minority were able to elect the Speaker, because they got at least one MPP member to vote for Speaker Bagwin. But now, if you have to remove Speaker Bagwin, the Constitution says that you require 3/4, right? Not just simple majority of 50+1. You require 3/4. So you have to have 75% of all members of Parliament voting in favor of the resolution to remove him. So that's what we call a special majority. So it's not just a simple majority. Florence, is your question answered?
Yes, thanks.
Okay. All right. Okay, the last exception, which is not really considered as a, actually, I should say that what is considered as a true exception to the Foss and Harbottle rule is the fraud and minority exception, right? That's what is considered as a true exception, but all these exceptions are considered broadly as exceptions to the rule. So the fourth one is the personal rights of shareholders. So personal rights of shareholders are rights of members that are personal to them, like the right to your shares in the company, your right to attend, speak and vote at a meeting of the company, your entitlement to dividends when dividends are declared. Those are your personal rights in the company, right? So those are personal rights. So dividends, right to attend meetings and speak at meetings and vote on resolutions, etc. Those are personal rights. So again, here too, if the decision that was taken by the majority of the company affects your personal rights, then the court will assist you and intervene, right? So the majority can say, well, okay, we are the majority of the company, so we can hold a meeting without giving you a notice to attend, right? They can't do that, right? Yeah, if they do that, then you can go to court and nullify the meeting, right? Because then otherwise you are being denied your right to even participate in the affairs of the company, or you have attended a meeting, but they will allow you to speak on the resolution, or allow you to vote on the resolution. Or your dividends have been declared, but the directors are refusing to pay your dividends to you, which is your personal right. You're entitled to it. If dividends have been declared, then you have to be paid your dividends. So if those things happen, then the member can sue, and the Foss and Harbottle rules will not prevent the suit from going forward. Any questions? Yes, let's start with Louisa.
Yes, sir. Please, you mentioned the true exception to the Foss and Harbottle rule. I think I didn't get it right.
The fraud and the minority exception.
Okay, thank you.
Christine.
Please, the first exception you gave, please, do we have any English case for that?
Which one was that?
Is the illegal.
Yeah, the legal, still the case of Edwards and Halliwell, which I mentioned for the second one, is applicable there.
Okay, and please, has there ever been a case in Ghana where the Foss versus Harbottle rule has been affirmed?
That's what we are coming to.
Okay, thank you.
All right. Any other question? Christine, your hands, do you have a question?
No, please, I'll bring it down. Thank you.
Okay. All right, no worries. Okay, now so let's look at the Ghanaian position. What does our law say about all these issues you have talked about, all these wranglings within a company where there's power wranglings, majority of the company wants to do something and want to use the company for their own parochial interest and are taking decisions that are illegal or ultra-vires or injurious to the interests of the minority and all that. What does our law say about that? Now, so the rule in Foss and Harbottle has been upheld in a number of cases. Both the proper plenty rule and the majority rule have been upheld in a number of cases. So let's try and look at that. So what is the basis that has been given for the courts to uphold the Foss and Harbottle rules? Now, like we mentioned, the rule in Foss and Harbottle developed from the common law. You know from the Ghana legal system class that in 1876, the Supreme Court ordinance was passed, and that applied the English common law and statutes of general application to Ghana. So the common law was transplanted into this country through the colonial experience we had. Now, when you look at the Companies Act, I think, let me check the new Companies Act, which section it is. But in the old Companies Act, it was section 7. In the new Companies Act, the 2019 one, let me see which section that is. I'm familiar with the old one, not the new one, because I studied company law a long time ago. So yeah, I think that's section 5 of the Companies Act 2019. So section 5 says that the rules of equity and common law applicable to companies shall continue in force unless they are inconsistent with the provision of this act. So section 5 of the Companies Act. Now, in the old Companies Act, Act 179, that was section 7. And it said basically the same thing. It said that the rules of the common law and equity applicable to companies shall continue in force except so far as they are inconsistent with the provision of this act. So the same thing. So section 5 of the old act, sorry, section 7 of the old act is what is now has been replicated in section 5 of the Companies Act. Now, so this provision forms the basis of the application of the rules in Foss and Harbottle in Ghana, because they are common law rules. So the law is that so long as any rules of common law relating to the company affairs are not inconsistent with the provision of the Act, they continue to apply. So when you look at some of the directors' duties, most of them, the fiduciary duties of directors, the fiduciary duties of promoters of the companies, etc., they are all, were all developed from the common law, and they continue to apply under the Act to directors and promoters, etc. All right, good night. See you Monday. So, so section 5 and the old section 8 of the Companies Act are what have been invoked by our courts as a basis for the application of the Foss and Harbottle rules in Ghana. But we'll go a bit deeper into it and then see whether there's a justification for the application of the Foss and Harbottle rule. We'll look at that shortly. So in a case known as, so let me give you the case of the Saradek case. I'm sure you know Saradek, the Saradek case is one of the famous cases. Central Regional Development Authority. Let me check the title and provide it to you. So that was a case of PI Investments Limited versus Central Regional Development Corporation. And that case was decided by the Supreme Court in 2012. So 2012 Supreme Court of Ghana Law Report, Supreme Court of Ghana Law Report 611. So it was in that case that Justice Doche sort of tried to rationalize the basis for the application of the Foss and Harbottle rule in Ghana. Of course, I mean, prior to that, the courts have applied it, but that case is where like he tried to explain the, if you like, the conceptual basis for the application of the rule. And he mentioned that it is based on the idea that the rules of the common law and equity that are inconsistent with the Act, Companies Act, continue to apply in Ghana. So in that sense, the Foss and Harbottle rule also applies. Okay. Now, so let's look at the cases that have upheld the Foss and Harbottle rule. So there's an old case. Yeah, somebody else put the title of the case there. Is somebody asking a question? Do these exceptions come under lifting of the corporate veil? Okay. Yeah, I mean, some of those exceptions, of course, yeah, would find themselves under the lifting the corporate veil. So you know that, like we mentioned earlier on, when a company is incorporated, it acquires a separate legal personality distinct from its members. So fictionally, we say there's a veil of incorporation that is sort of erected, separating the company from its members. Now, but there are certain situations in which the veil of incorporation may be lifted. And then we'll look behind the veil and see the people who are acting behind it and doing illegal things. Now, so obviously we have mentioned about, for instance, the fraud on the minority exception, where the directors or people in the majority are using the company for illegal purposes or etc. And so just like here, where the minority shareholder could go to court and sue, one of the grounds on which the veil of incorporation will be lifted and persons behind the company may be personally held liable for actions they have done is this. So if they are illegal, and again, as we'll come to see under sections 192, 192 of the Act, under the old Act, it was 203 to 205, which deals with directors' duties. So it deals with directors' duty, the duty of the director to exercise caution and skill and care towards the company, not engage in conflict of interest, etc. So those directors' duties are there, and the directors could be held liable if they breach those duties, and members are allowed to sue them. So yeah, so there can be some overlap when you're dealing with the Foss and Harbottle rule. Some of the grounds or the basis on which a minority shareholder may be able to sue would also qualify as a basis for lifting the corporate veil. So I hope your question is answered. Okay.
Yes, please. Thank you.
Okay. Now, so let's look at some of the cases that have upheld the Foss and Harbottle rule. So let's look at the case of Apenteng and Bank of West Africa, which applied what is known as the proper plaintiff leg of the rule in Foss and Harbottle. So the Apenteng case was not decided under the Companies Act 1963. It was decided under the old Companies Ordinance, but the provisions and the effects were similar. And also in subsequent cases decided under the Companies Act 1963, the courts had upheld it. So it's worthy of consideration. It's one of the cases that the courts usually refer to. So in that case, what happened was that the plaintiffs were shareholders of a company known as Importima Limited. I don't know what that means, but the Ghanaians have a funny way of naming companies. So yeah, it was called Importima Limited. And the shareholders sued Bank of West Africa for allegedly giving negligent financial advice to the company. So they were saying that the negligent financial advice that the bank gave to the company resulted in a loss, which by extension also led to a loss of or a diminution of the profits of the company, and by extension their dividends, which they were entitled to. So I think the company was going to do a transaction. The bank provides financial advice on the transaction, and then the transaction goes south, and then the profits of the company drop, and by extension, their dividends that they are entitled to also are lost. So they then bring an action against Bank of West Africa for this negligent financial advice that led to these losses, which they also suffered. Now, in that case, the court held that those shareholders did not have a right to bring an action against Bank of West Africa because the so-called negligent advice that was given to the company. So if there has been any loss, the loss or the wrong done is a wrong done to the company, Importima Limited. And so it is the company itself which was the proper plaintiff to bring an action, and not these individual shareholders. So they could not bring the action. So the court dismissed the action on the grounds that they lack standing to do so. And if there was any person who was properly clothed with capacity to bring the action, it should be the company itself. And that means that it has to be the directors bringing the action on behalf of the company. So that's about the proper plaintiff rule. So you have a case which illustrates that. Then let's look at Pinaman and Abrokwa. So you have Pinaman and Abrokwa. It's also one of the very famous cases on the Foss and Harbottle rule. Now, so in Pinaman and Abrokwa, so you have three main people: Michael Abrokwa, James Mensah, and Francis Pinaman. They're all shareholders and directors of a company known as Ashanti Furniture Company. And then Mr. Pinaman was the managing director of the company. And Abrokwa and Mensah, the other two shareholders and directors, complained that Pinaman, who was the director, was behaving in a way and engaging in transactions and using the company for various purposes which were oppressive to them and in disregard of their interests. Now, they specifically charged him with mismanagement of the company's finances, exploitation of the company's business for personal gain, and unlawful demotion of Mr. Abroka from his position in the company. Now, so they brought this action in the High Court. And the High Court looked at the matter and agreed with them and said that indeed, Mr. Pinaman was had done those things which the minority shareholders were complaining about. So the court ordered him to account for some sums of money that he had taken from the company, right? And then Mr. Pinaman is aggrieved by this decision, and he appeals to the Court of Appeal. Now, so he goes to the Court of Appeal, and the Court of Appeal overturns the decision of the High Court. And in that case, Justice Lamte, speaking for the court, said the following. He said this: in this respect, the courts have held that the ruling Foss and Harbottle must be observed by the trial court and must not inquire into matters of internal management or at the instance of a shareholder interfere with the transactions which, though prima facie irregular and detrimental to the company, are capable of being rectified by an ordinary resolution of the company in a general meeting. It will be shown in due course that a learned trial judge fell into the error of inquiring into matters of internal management, such as, for instance, the complaints by one of the applicants that he has been demoted and that his post had been downgraded, unquote. So the Justice Lamte here is applying what is known as the majority rule, which says that if there's a complaint you have of mismanagement, disregard of your interest in the company, etc., all those things that have to do with internal management of the company, if it's a matter that can be resolved by a general meeting passing an ordinary resolution, then the court should not interfere in those matters. So the court, on that basis, overturned the decision of the High Court, which had been granted in favor of Abroka and his other co-shareholder, Mensa, and ordering Pinaman to account for some sums of money, etc. So the Court of Appeal overturned it, right? So that's the other case that, there are other cases, but I'm sure you have it on your reading list, so you would go and look at it. But those are the two. I just wanted to illustrate the application of the Foss and Harbottle rules in Ghana. Then there is the case of Seredek, which I've already told you about, which was decided by the Supreme Court. So in the Seredek case is important, and the reason it's important is because in the Seredek case, the Supreme Court sort of does a review of all these prior cases, Pinaman and Abroka and all the Apenten and Bank of West Africa and other cases, to sort of reevaluate the basis on which the Foss and Harbottle rule applies in Ghana, right? So you should read that case, it's important. And the Seredek case is quite an interesting case. So what happens in that case is that you have the Central Regional Development Corporation, Seredek, which owns, at the time, it owned 40% of the majority shares in Chifo oil palm plantations. I'm sure some of you may have heard about Chifo oil palm plantation. Top. No, so yes, so the Central Regional Development Corporation held majority shares in that Chifo oil palm plantation. Now, the Chifo oil palm plantation regulations, or the constitution as it is now known under the New Companies Act, this constitution had a clause which we call the first refusal preemptive clause. So what that basically means is that if you're a shareholder and you want to sell your shares there's what is known as existing members of the company have the right of first refusal. What it means is that you first have to offer your shares to the existing shareholders. If none of them is interested in buying the shares, then the shares may then be offered to persons outside of the company, right? So the Chief Oil Palm Plantation Constitution contains such a clause, which entitled existing members of the company to give the right of first refusal. If you have to offer it to them first. If they refuse, then you can go out and sell the shares. So that was a regulation. And then in 1997, the government of Ghana held shares, which held shares in the Chief Oil Palm Plantation through SAREDEC. So I told you about SAREDEC, the Central Regional Development Corporation. It's a government entity. They were holding the government of Ghana shares in Chief Oil Palm Plantation. Now in 1997, the government of Ghana decided to sell 40% of its shares that it held in Chief Oil Palm Plantation. So ordinarily, as I've told you, the constitution contained the right of first refusal. So it means that the government of Ghana shares in Chief Oil Palm Plantation, the 40% that it wanted to sell, should first have been offered to the existing shareholders of top Chief Oil Palm Plantation. And if they decided not to buy, then the shares could be offered to entities or persons outside the company. But this was not what was done. So the government decided to sell the shares, and then the government tasked a body known as the Diversity Implementation Committee. I'm sure you have heard about it in Ghana's history, which that was a body that was involved in divesting most of Ghana's state corporations and access to private entities in pursuance of this liberalization of our economy. So the DIC, Diversity Implementation Committee, was supposed to oversee the sale of the shares. And they adopted an open tender approach or process, which offered the shares openly to anybody who was interested. So it means that the shares were not first offered to the existing shareholders of Oil Palm Plantation, but the shares were offered generally to anybody who was interested. And then at the end of that tendering process, Unilever Ghana Limited was selected as the highest bidder for the 40% shares. And so the shares were offered to Unilever. And then PSI Investment Limited, which was an existing shareholder, said, no, this is irregular. You cannot do this. The regulation says that you should first offer the shares to those of us who are within the company. If we refuse or do not exercise our right to buy it, then you can give it to people who are outside. But why do you go through a process where you invite everybody at once to come and participate in the process to buy the shares? So PSI then brings a suit against SAREDEC, the Central Regional Development Corporation, and Unilever and DIC and all those people involved, the directors who offer their shares, etc., etc. Now, so at the High Court, the defendants argued that the irregularity was one that could be remedied by the company, so the plaintiff was not entitled to sue. And the High Court agreed with the defendants on this point and held that the plaintiff's witness admitted during cross-examination that the irregular procedure complained of is capable of being rectified by a special resolution of the company. So then it decided not to interfere. The court dismissed the action. And this was affirmed by the Court of Appeal. Then the case went to the Supreme Court, and then the Supreme Court also considered it. And then that is what brought about this whole context of considering the continued applicability of the Foss and Harbottle rules, the extent to which they apply in Ghana, etc. So the court, speaking through Justice Doche, then says that when you look at the Companies Act, that was the Companies Act 1963, he said that the overall effect of these statutory provisions is that the proper plaintiff leg of the Foss and Harbottle rule has been whittled away significantly. And we'll come to explain that. A member of the company is allowed to bring an action where it is alleged that the member's rights have been violated. The Act even allows members to bring representative actions, be that as it may, on the basis of decisions like Apenteng versus Bank of West Africa, which I just told you about, and Pinaman and Abrokwa. The court will still uphold the majority rule upon a finding that the irregularity or act complained of is one that can be remedied or regularized by an ordinary resolution. So the conclusion the court reaches in that case, in the Saradek case, is that the Foss and Harbottle rule applies in Ghana. But then the court made some reservation. First, it says that the proper plaintiff rule has been whittled away significantly. So it still applies, but there are a lot of exceptions to it. So it doesn't have the same force as it did under the common law rules. And then number two, it goes on to say that the majority rule has also been sort of like reformed, but on the basis of decisions like Apenteng and Bank of West Africa, and then Pinaman versus Abrokwa, the court will still uphold the majority rule, right? So that's what the court says. That when you look at the Act, the Companies Act, it has made several inroads into the Foss and Harbottle rule, but it has not completely killed it. So the proper plaintiff rule in proper cases may still apply, and that in appropriate cases, the majority rule will still apply. So that's what the court said in Saradek. Now, if you read my article, which I did with Mr. J. Bediakon of KNUST, we hold a contrary view, and we argue that the courts have misconceived the real effect of the statutory inroads that have been made on the Foss and Harbottle rules. Okay, so let's try and look at another Ghanaian law. So generally, if you go by Pinaman and Abrokwa, and Bank of West Africa, and Saradek, and the other cases, the position is that the Foss and Harbottle rules still applies. So, but then they have been whittled down to some extent. So they do not apply in their full extent. Any question up to this point before we go on to the last part?
Remedy that's wrong.
Any question up to this point?
Hello, sir.
Yes, Louisa.
Please, can we have the citation for the Saradek case? The full case.
I gave the citation earlier. You are not paying attention. Okay, let me check. So the Saradek case, PSI Investment Limited versus Central Regional Development Corporation, that is 2012 1 Supreme Court of Ghana Law Report, page 611. You got that?
Thank you. Yes, seen it.
Okay. Any other question? Okay. Now,
So sorry, just a quick one.
yes, Kwabena.
So when the Supreme Court, I mean, in your view, I think you mentioned you disagree, but when the Supreme Court held that it's been whittled down, does it mean that it's no longer as effective as it could be applied? And from your perspective, does it inure to the benefit of minority shareholders?
Right. So yeah, one of the Supreme Court says that it's been whittled down. What it's basically saying is that, well, the rule still applies, but the scope of its application has been significantly narrowed because of various exceptions that have been created by the Companies Act. So basically, that's what the court means by that. That's what it means by it has been significantly whittled down. And then also in relation to the majority rule. But my view of this, and I invite you to read my article with Mr. Jibediak on this, my view is that if you look properly at the Act, the Companies Act, and the exceptions that have been made, the various provisions that have been made, that have been put in the Act to deal with issues of corporate governance and balance of power, etc. If you look at the combined effect of all those rules, my view is that the rules enforced by Harbottle no longer apply. But so that's my view. I think that the Act has sort of, if you like, has caused a parliamentary interment of the rule enforced in Harbottle. So it's been buried. It's supposed to be a dead rule, as far as I'm concerned, in Ghana. But the court has still applied it, and I can't really see the strong justification for its application. That's my view of the matter. But I'm not a Supreme Court, so my view is not a law. All right, Jennifer.
Thank you so much. We are really learning a lot. So my question is, if the rules have been whittled down, so in other words, the proper plaintiff rule does not apply anymore in the Ghanaian context, and then the majority rule also doesn't apply. Am I getting this right?
Yeah, that's my argument. But like I was saying earlier on, my argument is not a law. So take it with a pinch of salt.
So based on like looking at Section 7 of Act 179 and then Section 5 of Act 2019, is that it? Or there are certain sections of the Act that Companies Act that you are supposed to look at?
Yeah, there are some sections that we are going to look at, and we are going to look at them shortly.
All right, sure. Thank you so much.
Okay. Yes, any other question, Victor?
Yeah. I think I want to first of all, thank you so much for the lesson. It has been good so far. I think I want to agree with you on the issue that these two rules are no more applicable in the Ghanaian law, simply because looking at the case of PS Investment versus Central Regional Development Corporation, I was thinking that the court would give the plaintiffs the benefit of the doubt in the sense that they, by the directors of the company, they instituted the tender issue. Meanwhile, that the shareholders should have been given the opportunity to have the shares first, and if they fail before it can be other members can be allowed, or other people can be allowed to access the shares. But in this case, the court just applied the other rule. That's rule number 2. That when the matter requires a special majority to deal with it. So in this case, it means that the court ignored the two rules completely. I was thinking that maybe looking at it in such a way that because the company, the directors have given the shares out, it means that they are performing acts that are ultra virus. Therefore, the court should have given the plaintiff the benefit of the doubt to try the case. But I've realized that they just ignored the whole thing. So I think I agree with you on the rules not being applicable in the Ghanaian case. Thank you.
All right, thanks. Any other question?
Just like another one. So, but doesn't this open a floodgate with respect to minorities seeking to ensure that they are not taken for granted?
Well, the floodgates, in my view, the floodgates has been opened by the law. It's the law. So that if there's a floodgates or anything so-called floodgates, it's the law that has opened it, right? So yeah, and so when I'll come to explain these things, and then I'll look at. It doesn't mean that because you have the right to maybe sue, etc. It means that in all cases, that right has to be exercised, right? Or that the courts will necessarily admit the case. There may be some consideration, so I'll come to discuss this one. Let's move on and let's see how the discussion goes. Now, so the court said in Seredic that the Foss and Harbottle rules continue to apply, although they have been whittled down. And my argument, together with Mr. J. is that the proper conclusion the court should have drawn is that looking at the sheer number of exceptions and the extent, not just the number of exceptions, but the extent of those exceptions, the legal effect. When I say extent of the exception, I mean in terms of the legal effect of the exceptions. A careful reading of the Act should lead to a conclusion that the rule in Foss and Harbottle is no longer applicable in Ghana. Right? That's our conclusion. But so let's try and expand on that discussion, and let's see if I can convince you with my thesis on this point. Okay. So let's look at the first, the proper plenty rule. So we have said that the rule in Foss and the rule in Solomon and Solomon is that the company is a separate legal person, it conducts its own business, and it does so through the board of directors. So that so that's the basis of the proper plenty rule, that if a wrong is done to the company, then the proper person to sue is the company itself through its board of directors. So when you look at the Companies Act, I'm not sure which section that is in the new one, but like I said, I'm old school, so I'm more familiar with the old one. So in the old Act, section 137 says that the business of the company shall be managed by the board of directors, who may exercise all the powers of the company as are not by the acts or regulations required to be exercised by the members in general meeting. I'm not sure which section that is in the new Act, but I'm sure you are familiar with it. So, but it's the same section. So it says that the same principle. It says that the board, Gilbert.
Thank you, sir. A brief comment on what you just said earlier, that the rule in Foss and Harbottle is no longer applicable in Ghana. Let's consider this. The proper plaintiff rule that you just mentioned. Mm-hmm. Anytime the company does something wrong, mm-hmm. It is the company that is sued. So if that is the scenario, we'll also stick to the earlier statement that the Foss and Harbottle rule is no longer applicable in Ghana, because by understanding, an aspect is still applicable because when the company errs, it's the company that is sued. And is this not part of the rule?
No, no. I think you misunderstood what I said. The rule is the proper plaintiff rule, not the proper defendant rule. Right? So we are saying that the rule is that we are saying that if a wrong is done to the company, if the company suffers a wrong done by a third party or by a member of the company, directors, etc., the proper person to sue is the company itself. So we are not talking about, we are talking about proper plaintiff rule, not proper defendant. So I don't know if that clarifies your question, your confusion.
No, it's still not clarified. I said the same. I said,
what's your question?
Yeah, you said the rule Foss and Harbottle is no longer applicable. And I'm saying that when you consider the proper plaintiff rule, anytime that the company does something wrong and third parties suffer some kind of injury, it is the company that is sued.
Yes, and I'm telling you that no, you are inverting the discussion. You have inverted the whole thing. What we are saying is that if a wrong is done to the company, not the company doing a wrong to someone, that's not what we are saying. Gilbert. Yes, what we are talking about is a situation where a wrong has been done by someone to the company. We are not talking about situations where the company has done a wrong.
Okay.
You get what I'm saying?
Yes. Okay.
So that's what the proper plaintiff rule is about.
Okay.
You get it?
So yes. Thank you for the clarification. So granted, if that is the situation, then when you are saying that the Foss and Harbottle rule is no longer applicable, does not conflict it, because that is still the situation in Ghana, that when something is done, when a wrong is done, the company.
Yeah, no, Gilbert, you have to pay attention to what I'm saying. No, I said that in my view, based on my assessment of the provisions of the Act, my view is that the proper conclusion the Supreme Court should have drawn in Saradek is that the Foss and Harbottle rule is no longer applicable. That's both the proper plaintiff and the majority rule. But I added a caveat and said that I am not the Supreme Court. So the legal position is that those rules are still applicable, although in a significantly whittled form. So that's what I'm saying. This is an academic class, right? This is an academic class. So that's why I'm trying to help you to, to intellectually stimulate you in so that it's not just about you reading the sections of the Act or cases and just memorizing the ratios. And that's not what this discussion is about. It's an academic class. So you're supposed to understand the conceptual and opinions behind what you read and question what you read and be able to form your own judgment or opinion about what you read. So that's what the discussion is about, isn't it? So that's why I'm offering you an alternative view of what the court has decided. And then you can make up your own mind. I mean, you are free to disagree with me and agree with the Supreme Court. In any case, their word is a law. So you don't really have a choice. but I'm just offering you an alternative view so that you can also sort of think through it. That's what I'm saying.
Okay, thank you.
Yeah. Okay. Right. So the law says that the board of directors are the people who have the power to manage the business of the company. And that means, therefore, that managing the business of the company includes all aspects of managing the company's business. That will include bringing suits in the name of the company if a wrong is done to the company, right? If the company enters into a transaction and the other party has not fulfilled its obligation, or there's a tort committed against the company, there's trespass on the company's land by a person or entity, etc. It's a board of directors who have the authority to bring a case to litigate all those cases, right? So then you may ask yourself, then why am I saying that if it's the board of directors who have the power to...
Thank you very much.
Please
Misha.
mute yourself. So if it is a board of directors who have the power to bring all these suits that I'm talking about, if there's a contract that has not been fulfilled by the other party, there's somebody trespassing on the company's land, there's somebody who has committed a tort against the company, etc., etc. If it's a board of directors who have the power to manage the business of the company, including litigating cases on behalf of the company, then why am I saying that the proper plenty rule still does not apply, right? Does not apply in Ghana, right? Okay, so let me try and explain that, what I mean by that. Now, so the point, the argument I am making, together with Mr. Ajay, is that when you look at the proper plenty rule, especially in the context of how it developed in Foss and Harbottle, the idea that the company is a proper plaintiff is not necessarily about litigation of any and everything, every transaction, every litigation that a company may be engaged in, right? So the proper plenty rule is not necessarily about who may be considered as the litigator at large of the company, right? That is not what it's about. So that's our argument. That, of course, it is the board of directors who have the authority to manage the business of the company. So they ordinarily have the power to sue on behalf of the company. But strictly speaking, if you look at Foss and Harbottle and all other cases that were decided along those lines, the issue in those cases always concerned situations where the directors or people in control of the company had engaged in a certain malfeasance, right? So when we talk about the proper plaintiff rule, we are rather talking about who has the right to sue on behalf of the company when persons in charge of the company have used the company to engage in malfeasance that has caused an injury to the company. So because that was the context in the Foss and Harbottle case itself, right? Because the directors of the company were trying to sell a land to the company at an inflated price, and they were going to get money out of it. And we mentioned Harbottle and Meriwether, where some people were trying to sell a mine to a company, and they were going to make secret profits of 3,000 and 4,000 pounds, respectively. I mentioned that also to you. And there's the case of McDougall and Gardner, where the allegation was that the directors had colluded to stifle discussion with a view to carry out certain measures injurious to the company without submitting them to the general meeting. So if you look at Foss and Harbottle, Harbottle and Meriwether, McDougall and Gardner, and all its line of cases, you realize that anytime the issue of proper plaintiff comes up, it was in relation to a managerial malfeasance that had occurred. That is, people had engaged in conducts that were improper, fraudulent, etc. And then the question was, who should be entitled to sue in those cases? So, of course, if you say that the proper plaintiff rule is about who can sue in respect of all transactions of the company, then of course you are right, that is the board of directors or the company itself. But if you are restricting it to its proper meaning or to its proper context of cases where persons in charge of the company are committing malfeasance and therefore committing a wrong against the company, then it's a more narrower class of suits we are talking about, right? So if we agree on that, then we can now look at our Companies Act and see whether in respect of those smaller class of suits that involve managerial malfeasance, whether in respect of those class of suits, it is only the company that can sue or other people are allowed to sue. If other people are allowed to sue and have the same right as the company in respect of all those matters, then it means that the proper plaintiff rule no longer exists, right? is there clarity on this point? This point is important. So let me come back to you for feedback before I move on. That nobody is left behind.
Repeat again.
Yes.
Louisa, do you understand what I said?
Yes, I do say.
Okay, try and explain it to your colleagues. Let me hear.
Okay, so we are saying that for the proper plaintiff rule, it means that in the narrow sense in Foss and Harbottle,
yes,
the holding for proper plaintiff rule was that only the company through its board of directors is the proper plaintiff to sue for any malfeasance concerning the company. However, with the updated Companies Act incorporating common law and equity rules, it gives other shareholders or members of the company, not only the board of directors, the right to be able to sue for the company in a representative capacity. So it is not now only restricted to board of directors, but also to members or shareholders or class of debenture holders or any group of people who can now sue to enforce the interest of the company, especially in the case where the directors or board of directors are guilty of misconduct, liable for misconduct.
Yeah.
That's it. So in that case, now the proper plaintiff rule, the ground has been taken from under it. So it doesn't happen.
Okay, I think you understand it. You've done a very good analysis of the situation. Does everybody understand this point, or should I repeat it? Should I repeat it? So let me try and illustrate. So for instance, let's say that, so I said that as a general rule, the board of directors are the ones who manage the affairs of the company, right? So, and that includes litigating all matter of things on behalf of the company. So there's no question about that. So if you are talking about it in that broad sense, then of course, the company is always a proper plaintiff. But like Louisa mentioned, if you are looking at it in the proper sense or in the narrow sense, Foss and Harbottle was not concerned with the question of who has the power to litigate any and every matter on behalf of the company. That was not what the case was about, right? That was not what the case was, and subsequent cases that I have mentioned, that was not what the cases were about. So for instance, if the company enters into a contract with another person and there's money owed under the contract that is payable to the company, and that third party or person has not paid the money, of course, that may be a loss to the company, right? But the board of directors are the ones who manage the affairs of the company. They can say that, okay, we've been doing business with this company for a long time. He owes this money to us. Maybe in consideration of future business that we can get from the company, it's in our interest maybe to write off this debt, which is like, I mean, maybe the person owed 100 million, they've paid, that would maybe like, that's like 10,000. That is not much. We can write it off to be able to maintain our continuing business relationship with the person so that we can get more business in the future. The board of directors can decide to do that if they think that it's in the best interest of the company, right? Or they can sue. They can bring an action and sue to recover the 10,000 that is left. They can decide to do that. Now, if the board of directors have not collected this 10,000 that is owed under the contract, and a shareholder or a minority member of the company decides to go to court to sue over this 10,000 that remains uncollected, of course, the suit should be dismissed because it is the board of directors who can or who have the authority to conduct the business of the company, including litigation, right? So obviously, the suit should be dismissed for lack of standing. But that situation will be different if, let's say, the money that is owed is not being paid because the board of directors have done a secret deal between themselves and the person who owes the money not to pay, so that maybe they are getting some kickback or whatever, some personal benefits. That's why maybe they got some the the third party who did the contract with the company has made some gifts, paid the school fees of one of the board of directors whose children go to school abroad. So then that's why they decided that they would write off the debt or whatever. If that is the situation, then the situation which would have just been a simple debt situation, which the board of directors will be competent to deal with, has now risen to the level of managerial malfeasance. So then we are now looking at a Foss and Harbottle situation, because now we are looking at a situation where there is misconduct involved, because it's not just the board of directors exercising their business judgment to say, let's write this debt off and not let the third party pay because it's in the interest of the company to do so, right? So what I'm saying is that if it's an ordinary business which does not involve any malfeasance, then of course, the board of directors have the right to conduct that business. And so no issue of a third party, a member of the company suing on behalf of the company. But that is not what, in my view, that is not what the Foss and Harbottle rule is concerned about. The Foss and Harbottle rule is not concerned about on every day-to-day basis who can sue on behalf of the company. The Foss and Harbottle rule is concerned about situations where a wrong has been done to the company, and all those wrongs normally involve misconduct by either board of directors or other persons who have control of the company, like majority shareholders. So those are the situations we are talking about. So if we understand it in that sense, that is what the proper plaintiff rule in Foss and Harbottle is about situations, that small category of cases where managers of the company are engaged in misconduct or malfeasance, then we can now have a basis to now examine the Companies Act, like Louisa said, and see, based on its provisions, whether it is only the board of directors that has the standing or the capacity to sue or to bring an action in respect of those cases, or other persons like members, the registrar, etc., under the Act may also bring a suit or challenge those actions. If our conclusion is that it is not only the board of directors, but other persons like members, etc., can also do it, then it means that there is no basis to continue to say that the proper plaintiff rule applies. You get it? So that's the explanation I was giving earlier on, which Louisa expertly summarized. Yes, Kobina.
Okay, so I think in this case, you use when you talk about the Foss and the Harbottle rule, you use there are two elements of it, but in the analysis, we seem to focus on the proper.
Yeah, because we are taking it one after the other. We are dealing with the proper plaintiff rule first.
Okay, all right, that's fine. Then maybe my question doesn't come in. Otherwise, I was going to say then, does the remedy only lie in the court action, or the members have the option also to use the majority rule to sort of penalize the directors by either removing them, in which case you probably will still say that the majority rule option is still available within the Foss and Harbottle rule?
I don't quite get your question, but maybe as I explain, as we go on to discuss the majority rule, maybe your question will be answered. So reserve it for now.
Okay.
Yeah.
All right, sure.
Okay. Okay, so now that that premise is clear, now let's look at the various sections of the Act. Now, so another old Act, that was Section 205, Directors' Duties. Another new Act is Sections 190 to 192, I believe. You can check it. So those sections of the Act prohibit directors of the company from engaging in any act that will be injurious to the interests of the company. So if there is a contract in which the director is interested, they have to disclose that interest. They have to act with care and skill, be diligent, not to cause any injury to the company. The director cannot use the company's money or property or confidential information or special knowledge obtained while acting on behalf of the company for their own businesses or on behalf of another business that competes with the company, or cannot go and set up, while he's still director of the company, set up a business that competes with the company, etc. So there are several liabilities, and so there are fiduciary duties, etc. Duties relating to honesty and not to get secret profits, in personal advantage, all that. And so all those duties are there. Now, when you look at the proper plaintiff rule in Foss and Harbottle, those are issues of malfeasance, directors using the company for their own personal interest, etc. Are all those things that are addressed by sections 190 and 192, right? And then when you go to section, I think it's 198 under the new act. Let me check to be sure. No, rather section 200, under section 200. So 192 to 190 to 192 deals with the director's duties, etc. Then 200, let's read it if we can. Section 200, then (200) says that proceedings, so 200 is legal proceedings to enforce liabilities. So liabilities have been defined. Then section 200 says that proceedings may be instituted by the company or by a member of the company to enforce the liabilities referred to in section 119 to 199, restrain a threatened breach of duty under sections 190 to 192, or recover from a director of the company a property of the company. And then subsection 2 says that proceedings may be issued by the company on the authority of the board of directors or receiver or manager or liquidator of the company, or of an ordinary resolution of the company which has been agreed to by members of the company entitled to attend and vote at the general meeting, subject to section 5 or subsection 19 at the general meeting for the purposes of neither of the proposed defendants nor holders of shares in which or any of them are beneficially interested shall vote on a resolution, if any, or if any of them do vote, the vote shall not be counted. And then after an investigation of the affairs of the company, proceedings may pursuant to section 234 be instituted in the name of the company by the registrar. So when you look at section 200 under the new act, it gives a member the right to sue to enforce the liabilities of a director, right? Which is what Foss wanted to do in Foss and Harbottle, and the court said he could not do it because he was not a proper plaintiff. But under section 200, the court, the act does not give any priority. So it's either the company itself or a member, right? Clearly from section 200, there's no priority that is given to the company over the member in terms of who can enforce the liabilities of the directors if they are engaged in malfeasance, like what happened in Foss and Harbottle under our act. So clearly you can see that the members' rights to sue and the company's right to sue are at par. The one is not subservient to the other. You get it? So that's my principal argument for saying that. In light of that, you can see that the proper plaintiff rule, in my view, is as good as dead, because if the company is not given priority in terms of who, in terms of suits against directors or other persons for injuries against the company, then the proper plaintiff rule, the special status of the proper plaintiff rule is no longer exists, and so it's as good as dead. You get the point I'm making, right? So that's the argument I'm making. Now, but it doesn't mean that. Now, let me get to the prudential aspect. So then it doesn't mean that the member, if a member wants to sue, he can just get up and go and sue. Of course, he can do so, right? But what would be the proper way to do so? The proper way to do so would be, okay, I observed that there's something going on wrong in the company. He can approach the board of directors or maybe call a general meeting and try to resolve it. He's not required to do that because Section 200 does not require the member to go through that process, right? He has to say, okay, deal with it, or if you don't deal with it, then I'll go to court. There's no requirement that the member must first make a pre-suit demand on the company to fulfill that. But in my view, it may be prudent to do so because if the member decides to prompt the company to take an action and the company does take action to resolve the matter, then the minority member will then not go and waste his money and time in court to litigate the same matter, which if he had prompted the company about, the company could have resolved. So if a member goes to court to enforce director's liabilities or to challenge some other action that has been taken, which is irregular or illegal, the person has standing to sue. They don't need to show that they have first prompted the company to take action because the law does not require that. If they want to take that prudential step by informing the company or prompting the company to take some action, then they may decide to take that prudential step by themselves. But the law does not require the member to do so, right? And in my view, based on this, the court cannot dismiss the action on the basis that the company is the only proper plaintiff that has to sue. If the company comes to court and say, we are taking action to resolve the matter, the only thing, in my view, the court could do in those circumstances would be to say, okay, let's stay the action of the member and let's see if the company can resolve it through their board of directors or through a general meeting or whatever, as they claim they want to do. If the matter is resolved through the board action or through a general meeting, then of course the court may then strike out the suit because then the case will be moot, right? Because then the object for which the action was brought would no longer exist. But if the matter is not resolved through either the board or any other internal procedure, then the court must proceed with the suit and determine it. And if the member is right, make the appropriate orders, right? So my argument is that the Act does not give any priority to the company per se when it comes to those wrongs. When you look at the Act, it gives the right of the member to sue and the company to also remedy the wrong are at par, right? They are at par. So the member may come to court and sue, and the court should not dismiss the action merely on the basis that of the proper plaintiff rule under common law. When the Act is the law that, that the common law rules are supposed to be subject to the Act. So if the Act does not make a distinction or give priority to the company in a suit to redress wrongs, including all those directors' malfeasance, which are normally what would be the basis for wrongs against the company, then the basis of the proper plaintiff rule in Foss and Harbottle is broken totally, in my view. Well, but the Supreme Court thinks otherwise. So take my my view with a pinch of salt. Okay, any question on that? Yes, Helen.
Good evening. Please, so can we then conclude that the Section 200 of Act 992 takes precedence over the proper plaintiff rule under common law?
Yes, the common law is subject to all acts of parliament. In the hierarchy of laws in Ghana, you have the Constitution, acts of parliament, subsidiary legislation, regulations, and constitutional instruments before the common law. So the common law is retained subject to statutes. So if the common law is in conflict with statutes, the statutes will prevail. That's the law. Okay, but it doesn't mean that it's a law in effect. My view is that is a law, but the Supreme Court thinks otherwise. So what they say is what we go with. So yeah, you get it.
Yes, please.
Gilbert.
Okay, thanks. So if a member comes to court with an action, normally does he do so in his personal capacity or often on behalf of the company?
Well, so the company side, I think the old one, I think the new one as well, says that in enforcing, in bringing these suits, either to enforce either the regulations or I may also think so the director's liabilities, the member has to do so in a representative capacity. So the member has a right to sue, but generally it has to do so in a representative capacity. Is your question answered? I think there's one of them. There's I have to check and be sure. Wait, I have to check and be sure. There's one of those provisions under which the member has to sue in a representative capacity. I think it's more in relation to the enforcement of the constitution of the company. I'm not sure if it's in relation to also
I'm asking so for a simple reason, in that if the member comes to court on behalf of the company, and if it were also a director, he would do so on behalf of the company, then I don't see the difference. Whether it's a member or a director, if they are doing so on behalf of the company, then it's almost the same thing.
They are not what?
I'm saying that if the member brings the action on behalf of the company, and a director also will issue an action on behalf of the company, then whichever actually initiate the action, it amounts to the same thing because they are all doing same on behalf of the company. And if that's the case, then I do not see the reason.
Yeah, but that is the point. That's the reason. That's the reason why I'm saying that then in that case, the proper plaintiff rule is no longer applicable, because ordinarily the persons who are entitled to sue on behalf of the company by law are the directors, because they conduct the business of the company, right? So the decisions of the company may be taken normally by the decision of the board of directors, and also in some cases by resolution of members. But generally it's the directors who act on behalf of the company. Now, when it comes to Foss and Harbottle wrongs, malfeasance by directors and other persons in control of the company that injures the company, the common law position was that it is the company itself that has to sue, which means that it's the directors that must bring the action. Now, under our act, as we are discussing, the act gives a member the right to sue to enforce director's liability, which covers most of the things we are talking about, all the issues related to malfeasance of members that injures the company, conflict of interest, fiduciary duty, bribery, and using information of the company for their personal gain and in competition with the company. All those things that would normally come within Foss and Harbottle wrongs are all covered in the director's duties. And the law gives a member the same right as it gives the company to be able to bring the action, to remedy those wrongs against the company. So that's why that's the basis for the argument I'm making. That if you look at it in that sense, then the proper plaintiff rule, which sought to preserve the special status of priority of the company to sue to remedy wrongs to the company, that's no longer exists in Ghana. That's the point I'm making.
Essentially, I think I'm also saying the same thing. If it was the director,
okay, maybe in different ways.
If it was the directors who actually brought an action, they will be doing so on behalf of the company. Per Act 992, it's also saying that members can also do the same. And these members are also bringing the action on behalf of the company, not on their own behalf.
Yes.
So, it's not the same thing. I think the same thing. How come that the Foss and Harbottle's rule is no longer applicable? If the members
no, you don't. That's where you're getting it wrong. That's where you're getting confused. Let me explain.
If the members were to do so on their own behalf, then I will appreciate that argument. But in this case, they are doing so on behalf of the company.
No, but
Even the directors have also done same.
No. But the Foss and Harbottle rule has. That's why I told you that the true exception earlier on. I mentioned it. The true exception to the Foss and Harbottle rule is the fraud on the minority exception, which is where members bring what we call derivative action to remedy wrongs that are done to the company. Now, so in all those cases, including Foss and Harbottle, where members were trying to sue to remedy a wrong, they were not pretending to do so in their own interest. They wanted to do so to remedy a wrong done to the company. That was the basis for the action. That these people are committing wrongs against the company and they are not doing anything about it. So we are bringing an action to stop it. That was the basis for all those actions. And the court said, no, you cannot act on behalf of the company. The person to act on behalf of the company is the company itself through its board of directors, right? And now you concede. Oh, wait. Now you also concede that under our act, the law gives a member a right to bring a derivative action, which is also whose purpose is also to litigate a matter to protect the company. So in a sense, they are acting in the interest of the company, just like the directors will do. So if the proper preemptive rule under the common law, we say that it is only the directors or the company itself that can act on behalf of the company, and therefore granted the directors a special status or a priority. And now our act has removed that priority and says members can also bring the same action and does not make a distinction between the priority of the company or the directors to do so. Then it means that the whole thing about the proper preemptive rule, which gave a special status or priority to the board of directors, no longer exists. That's the argument I'm making. You get it?
Yes.
So that's the point I'm making. Okay.
Thank you.
Now, let's move on to the majority rule. So the majority rule, like we mentioned earlier on, said that, okay, if there's power wrangling within the company, some people have done some wrongs. Corbin, you have a question?
Yeah, my question is, doesn't section 200 just give a narrow focus on the elimination of the how do you call it, the Foss and Harbottle rule? I mean, narrowing the focus only to that of the directors, and I want to juxtapose that with the Harbottle and the Bank of West Africa situation, where the injury was to the company, not committed by the directors, but then the directors had not instituted the action, and yet the injury was to the companies and potentially the returns to the shareholders. So how do you compare that?
Oh, okay. So you mean that the section 200 limits the action just against the directors and doesn't go after third parties like what the shareholders in Harbottle sought to do. So to that extent, there's still a bit of the proper preemptive rule left.
Yes.
Okay, yeah, I think that's an interesting perspective to look at. But I think it may also depend on how you perceive the wrong that has been done or who is responsible for the wrong that has been done. So if you look at section 190 to 192 and the other following sections, it gives a very extensive director's duties. Those director's duties are very broad in terms of like conducting the affairs of the company in a manner that is skillful and diligent and cautious, as an ordinarily prudent and skillful director would do to avoid losses or injuries to the company. And then you have the conflict of interest duties and all that. So the question is, if a shareholder were to if you were to bring the facts of Append within the context of section 190 to 192 now, would we be able to fit it within, possibly within the, would we be able to have a basis for it, for such a suit under 192, 192, right? Now, so that is why my view, if you remember, I told you that not every action or matter on which the directors of the company or any wrong that is done to the company would come under the Foss and Harbottle rule. Because what I'm saying that the Foss and Harbottle rule is limited to a narrow situation of cases, which is cases that rise to the level of managerial malfeasance. Now, let's look at the case of Append and Bank of West Africa. The allegation was that the directors had gone to do a transaction. They had received advice from a third party, Bank of West Africa, and that the advice was negligent, right? The advice was negligent, so it has caused a loss to the company. And so they were suing the third party. Now, generally, if a company receives a wrong advice, or like I mentioned, a tort is committed against the company, that would ordinarily fall within the managerial powers of the board of directors. So they will be entitled to sue. So actually, I don't think the court reached a wrong conclusion in Append and Bank of West Africa by dismissing the suit. I think it was the proper thing to do, because ordinarily, if you claim that a tort has been committed against the company, then it should be the board of directors who would sue. So I wouldn't consider Append and Bank of West Africa to be one of the classic Foss and Harbottle cases, because as I told you, the premise of my thesis is that we must be looking at situations that rise to the level of managerial malfeasance, right? So if it was the case that in Append, right, if it was a case that maybe the directors had received kickback, they have done some other, wrong things, which led to the wrong advice, right? Then I think it will fall within one of those classic Foss and Harbottle situations. But merely contracting a bank to do business for us, and then the advice they gave turns out to be wrong, I don't see that to rise to the level of the classic Foss and Harbottle situation where you have managerial malfeasance involved. Now, obviously, okay. So the other point I want to make is that if, let's say, beyond the point where the advice was wrong, right, and maybe the board should have taken an action to sue the bank, but they didn't do it, and their reason for not doing so was constituted a situation which you can consider to be a managerial malfeasance or gross negligence or whatever it is, then maybe we'll be coming back to the Foss and Harbottle situation, which I think would fall in the section 190 to 192. So my view is not that every wrong against the company is a Foss and Harbottle wrong. That's why I delineated the discussion and said that Foss and Harbottle wrongs would only be those wrongs that rise to the level of managerial malfeasance or misconduct. So that if the case is not one that involves a misconduct, managerial misconduct, but it's just an ordinary case of like, oh, the company is owed a debt, a tort has been committed against the company, somebody has not paid a debt. Those are ordinary cases which the directors are entitled to deal with. So obviously, then they will not come within section 290. But it doesn't mean that section 290, section 200, in my view, would not have abolished Foss and Harbottle, the proper plaintiff rule of Foss and Harbottle, because my argument is that the class of cases that would come into that will fall into the Foss and Harbottle's proper plaintiff rule would almost always be one of those cases that come under section 290 and section 200. So that's my argument. I don't know if you are clear on that.
Yes, thank you.
Okay. Yeah, so that's my argument. So there may be some cases that may fall outside of section 200. But then there wouldn't be Foss and Harbottle, classic Foss and Harbottle cases. That's my argument, right? There wouldn't be classic Foss and Harbottle cases. Okay, let's look at section. Let's look at the majority rule. So the majority rule says that if a matter can be remedied through the internal process of the company, through a resolution, simple majority, etc., then no individual is allowed to bring an action. Now, but let's look at various sections of the Act. So, one, enforcement of regulations. Now, that and under the old Act, that was section 21. Under the new Act, that is section 29, enforcement of the Constitution. Now, the Constitution of the company is a contract under seal between the members of the company, and it binds members, officers, directors of the company. And then if the Constitution of the company gives a right to a person to appoint a person, let's say a director, that person may enforce that right as if they were a party to the a contract between all the members. So the Act gives a member the right to enforce any provisions of the Constitution of the company that is infringed, right? That is infringed. So when you look at section 29, let's see what section 29 of the Act says. So that, in my view, is one of the erosions or one of the reforms that erodes the majority rule. Because you may be the majority, you may take a decision. Ordinarily, if the majority rule says that if the decision can be remedied by a majority decision, that I am not entitled to sue. But again, you have a situation where the Act says that I can sue to enforce the regulations, and it doesn't give an exception as to whether it's a decision that could be remedied by majority of the company, so long as the decision is against the Constitution, because the Constitution is like a contract between us. So if there is an infringement of the term of its terms, I'm entitled to sue to remedy it. So that's what it says. So Article 29 says, subject to this Act, the Constitution has the effect of a contract under seal between the company and each member or officer, and between the members or officers by themselves, which they agree to observe and perform functions contained in the Constitution as amended from time to time, insofar as they relate to the company, the members or officers. And where the Constitution empowers a person to appoint or remove a director or any officer of the company, that power is enforceable by that person through, although that person is not a member of the company. In an action by a member or officer to enforce an obligation owed under the Constitution to that member or officer and any other member or officer, that member or officer, let me take it again. In an action by a member or officer to enforce an obligation owed under the Constitution to that member or officer and any other member or officer, that member or officer shall, if any other member or officer is affected by the breach of the obligation, sue in a representative capacity on behalf of that member or officer and all other members or officers who may be affected, other than any who are defendants, and the provisions of section 205 shall apply. Yeah, so a member has a right to sue to enforce the Constitution. So in my view, that is one of the exceptions to the proper plaintiff rule. No, sorry, not proper plaintiff rule, the majority rule. So that if, you heard me read it, it even gives, if the Constitution gives a third party a power to appoint or remove a director, that person may exercise that power as if they were a member. So if under the Constitution, I have a right to appoint a director, and now you decide that, pass a resolution that I cannot appoint a director of the company, I have a right to enforce it. And that is not, that has no, it makes no exception for that. You can remedy it by your internal procedure or not, Of course, if you decide to remedy by internal procedure, that's fine, and I may go with it, right? But otherwise, I'm not supposed to wait for you to enforce to remedy by internal procedure before I decide to go to court. If sorry, I'm in Nigeria and there's power outage, so the light went off, but I think it's back now. So that's the point I'm making, right? The first point. So enforcement of the constitution or regulations of the company. That is one of the exceptions to the majority rule, right? Then there's a prohibition of ultra vires acts. Another old act, that was section 25. Another new act, that is section 19. But I told you that, I mean, the new section 19 is not as powerful as the old section 25 because there has been some inroads made. Another old act, there were strict rules about the powers of the company and its capacity, etc. Now the rules have been relaxed a bit, unless the constitution of the company itself places strict limitations on the powers of the company. So, but in a case where those limitations exist, if the constitution specifies certain limitations to the powers of the company or the business, authorized business, etc., then those limitations must be observed by the company and its directors. So if there is any actions of the company or its board that exceeds those powers or limitations specified in the constitution of the company, a member is entitled to sue to enforce, to prohibit or nullify those ultra vires acts. So under section 19. So you should look at it. Then you have illegality, illegal acts, and irregular acts. That's under section 217, I think. Let me check. I think under both the old and new acts, they are all section 217 or 218. Let me check to be sure. Okay, just a minute. Okay, it's 218 now. It's not 217. Another old act was 217. Another new act is 218. So it's 218, injunction or declaration is in the event of an illegal or irregular activity. So it says that the court, on application of a member, may by injunction restrain the company from doing an act or entering into a transaction which is illegal or beyond the power or capacity of the company, or which infringes a provision of the constitution of the company, or from acting on a resolution not properly passed in accordance with this act or the constitution of the company, and may declare that act, transaction, or resolution already done, entered into, or passed to be void. Right? Subsection 1 does not derogate from protection afforded by a provision of this as a person dealing with the company. And then subsection 4 says a right afforded to a member to apply to the court does not limit the right that member may have to institute proceedings against a director of the company pursuant to section 200 or to apply to the court under section 219. So you look at section 218, it's a very broad section that deals with illegal and irregular acts. And it makes no exception for situations where the company may remedy or regularize or anything. It doesn't make any exceptions for those things. It just says that the court, on the application of a member, may by injunction restrain the company from doing an act or entering into a transaction which is illegal or beyond the capacity of the company, the power capacity of the company, or which infringes a provision of the constitution of the company, or from acting on a resolution not properly passed in accordance with this act or the constitution of the company, and may declare that a transaction or resolution already done, entered into, or passed to be void. You see, so section 218, which deals with irregular and illegal acts and ultra vires acts, makes no exception for situations where the conduct or action may be regularized or anything. And it doesn't make that exception. So that's why, in my view, the Pinama versus Abroka, and we had this provision, the same provision in the old Acts, Acts 179. So that's why, in light of those provisions, I find the decision in Abroka to be a bit curious, because if you are reading the Acts properly, then the court should have upheld. The Court of Appeal should have upheld the decision of the High Court, which said that Abroka was engaged in mismanagement of the company and had taken monies out, etc. The court should not have applied the internal management rule or the majority rule, which it did in that case, on the basis, in light of this provision. You see it. And then I would also invite you to look at Professor Gawe's commentary on section, the old section 217, which is now section 218. You know that the company, our company law, new company at independence, the government contracted Professor Gawa, who was an English company lawyer expert, to draft the company's code and the body's corporate official liquidation as another act. And then he did a commentary on each of the sections as to what he thought those sections should mean. And on section 217 of the old act, which is now section 218, this is what he said. He said that the fact that an irregularity could be rectified does not mean that no action should be possible to attack an irregularity which has not been put right. For myself, I see no reason why a member should not be allowed to institute proceedings attacking any irregularity, remediable or not. This is by far the best method of assuring that the rectification that does take place if the majority is prepared to rectify. If the rectification duly takes place, obviously the litigation will become futile and will be discontinued. If no ratification takes place, the action will continue and should succeed. If the law refuses to allow a member to litigate it, it may well be that the irregularity will never be rectified, but no one will be able to take steps to restrain the company from acting on it. So this is what the architect of the act, of the Companies Act, and the provisions that have now become section 218 said. And under the Interpretation Act, these preparatory documents, either memorandums or committee reports, etc., that illuminates provisions of the act, serve as aid to interpretation. So if the court is in doubt, it has to look at what Professor Gao is saying. And he said there is no reason why a member should not be able to sue whether the action, the transaction the company has entered into is one that can be regularized or not. And like I said initially, obviously, if the matter is one that can be remedied by the company, then the only thing the court has to do is to stay the proceeding, but the court has no basis to dismiss the action and say that, well, it can be remedied, so I'm dismissing the action. Because the act does not give any qualification. When it talks about irregular and illegal acts, it doesn't give any qualification that you can only sue if the irregular act is one that can be that cannot be remedied by an internal procedure. It doesn't give that qualification. So if the person sues and says this act is illegal or irregular beyond the powers of the company, ultra vires, etc., the court should not dismiss the action in light of the provisions of our act, dismiss the action on the basis that of the common law rule of proper plaintiff or majority rule. The court should not dismiss it. The only thing the court can do is if the company comes and says, well, there's one we can remedy, then the only thing the court should do is to stay the proceedings and allow the company to go and try to use their internal processes to remedy it. If they do so, then the action, of course, will become moot, like I said. And the court will then dismiss it and say, well, okay, the action now serves no purpose because what you wanted to do with bringing the suit has now been resolved. But if it's not resolved, then the action has to proceed, like Professor Guy is saying. And if the plaintiff has a good case, then the case must succeed. And the company must be injuncted from proceeding on that transaction, which is illegal or irregular or ultra vires. You get it? So if you look at this section, section 218, and Professor Guy's commentary, in light of Pinawana and Abroka and Seredek, you realize that it's at variance with the act. right? It doesn't. Those decisions don't sit well with the Act. Then the last one is remedy against oppression. So that was under Section 218 of the old Act 179, and now it's now under Section 219. Now, so oppression, as the court have held on a number of occasions, it's not a term of art. You see, a term of art is something, a word or phrase or term that has a special or acquired meaning, right? So let's say if you say virus has a number of meanings. So you can mean the pathological agent, a virus like COVID, SARS, whatever, or it can mean a computer virus. So if somebody says a virus, a computer science says virus, it doesn't mean COVID or some other virus, HIV or whatever. They mean something else, a computer virus. So then the word has a special meaning or a technical meaning. That's what we call a term of art. Now, the court have said that oppression is not a term of art, so it doesn't have any special meaning. So what it means simply is the ordinary language, what it means in the ordinary sense. If somebody is oppressing you, or to also, that they are doing acts that are putting pressure on you, that are unfair, that are prejudicial, that are discriminatory. So those are oppressive acts. So, so the act does not only give members the right to sue to remedy illegal, irregular, or ultra-vires acts, but also conduct that may simply be oppressive. They are prejudicial to your interest, they are harsh, they are discriminatory, they are prejudicial, etc. Right? Now, so what it means, therefore, is that under our act, the right of a member to sue, either on behalf of the company or in their own interest, to remedy wrongs that are done to the company or to their own interest, it's broad. The bases are so broad, right? Under Section 218 and 219, right? So it's not only illegal acts, even acts that are merely, well, not merely, if an act is oppressive, it's not a mere act. So acts that are may not be illegal per se. So it doesn't mean that you can only sue on the basis of illegal acts. The conduct may not be illegal, but if it's oppressive, if it's discriminatory, if it's harsh, right, then you can bring an action under Section 219, right? Because the majority is using their power to oppress you in the company, and they are doing things that they are not sacking you from the company, but the way they are doing things, you yourself will resign and go, right? That's sort of the idea, right? So if those things are happening, a member can bring an action under Section 219 of the Act, right? So if you take all these things together, Section 29, a member's right to sue to enforce the regulations of the Constitution. Section 217, which is very broad, to challenge any act that's irregular, illegal, ultra-vires, or beyond the powers of the company. And then Section 219, suit to challenge acts that are discriminatory, unfair, harsh, prejudicial. They may not be necessarily illegal, but so long as they are being conducted in a manner that's unfair, harsh, prejudicial, discriminatory, etc., the person is allowed to come and challenge all those in court. And there's no exception, like I said, as to whether the company can remedy those by their internal procedure or whatever. The company, the member, or even a director under Section 219 officer can bring the suit. The registrar of companies under the Act is also empowered to investigate affairs of the company if they are being run in a manner that is fraudulent, unfair, etc., and then obtain an order of the court to appoint what is known as, I think, investigators or something to investigate, and then the court can make orders subsequently. So if you take all these sections, their legal effect together, it basically means that this whole idea of proper plaintiff and majority rule is a legal fiction, right? It's a legal fiction. There's no basis for the court to continue to say that those rules apply in the face of these provisions. So that's my argument. Any questions?
Guys, any questions? Does someone have a question? You can raise your hand and ask. Any questions? Ask all your questions here, because the next thing then is an assessment.
So maybe just a quick one. So rather than saying that the Foss and Harbottle rule is abolished, can't we rather flip it and say that the elements of it and its weaknesses have rather been absorbed into the Act 992?
Have rather been what?
Absorbed.
How?
And corrected in 992.
How
because all the weaknesses of it, I mean, the exceptions to it have been corrected in 992 to the extent, I mean, based on the areas.
I'm sorry, I don't understand your argument. What do you mean by exceptions have been corrected?
So at the very initial stages, the exceptions to the Foss and Harbottle rules were the illegality, personal rights issues, fraud against minority and others. But if you look at the sessions we have looked at so far, the remedies are contained in Act 992. So then my point then is it not rather the case that the rule and its weaknesses have been absorbed and corrected into Act 992, rather than saying that they've been completely abolished and it's fictitious?
I'm sorry, I don't get the argument I'm making, but let me try to understand. So what we were discussing earlier on is that the English courts had a laissez-faire approach to corporate governance, so they didn't want to interfere too much. So that's what birthed the Foss and Harbottle rule, where the courts will stay their hands off, companies deal with their own matter. If there's a wrong to the company, let the company deal with it itself. If it's a matter that can be resolved by ordinary resolution of members, then let them pass a resolution and deal with it. Don't come complaining to us about issues within the company, etc. So that was the approach. But then they quickly realized that approach may cause hardship. So then they developed exceptions. And then we talked about the 4 exceptions that were developed: the fraud on the minority, the personal rights of the shareholder, the special procedure or special majority, and the other one, if it's ultra vires, right? Those 4 exceptions. Now, so those exceptions were developed, but still, under common law, the Foss and Harbottle rules applied. Now, what I'm saying is that when you look at our acts, though our act also has those exceptions, but their scope under our act is wider, right? Their scope under our act is much wider, so that if you examine the total effect of all those exceptions, I'm not saying that those exceptions are not in the act. Those exceptions are actually in the act. All the exceptions we've mentioned, when you look at the provisions, they are contained in the act. But their scope and effects are much more significant, to the extent that the exceptions have sort of, if you like, broken the foundation of the rule. That's the argument I'm making, right? I don't know if you get what I'm saying. So the exceptions are so many and wide and effective, to the point that the rule itself does no longer exist. You get the point I'm making. Governor.
Yes.
Yeah, so
Okay,
that's the argument I'm making.
Okay, so I get you. I think you're so okay. So this is how I'm viewing what you're saying. So you're looking at the rule and all the exceptions, or the rule and the exceptions. So then when you come into the act, then what you find is you have the exceptions fully contained in it. So what I'm trying to establish, is it a case, because the argument you make, is it a case of this is the rule or its exceptions, or this is the rule and its exceptions? So that if you're looking at it, the rule or its exceptions, then what you're saying would hold. But if you're looking at saying the rule and its exceptions, then what you're saying would hold. But if you're looking at the rule or its exceptions, then I still hold the view that
no, I don't understand the distinction you're making between like this thing between or and I don't get it.
Okay, so what I'm driving at is in looking at the rule, in looking at the rules within the law, do we look at it, the rule and its related exceptions, or we look at the rule and its exceptions separately?
No, but
it's a question. I don't know. I'm asking.
No, you have to look at it as a whole, right? We are discussing the rule and its exceptions, right? So we said the rule developed from the common law, right? You get it?
Yeah.
Are you listening? We said the rule developed from the common law.
Yes, I'm here. I'm listening.
It developed from the common law. And under the common law, there were exceptions that were developed, created to the rule. And then we came to look at why are we in Ghana applying the rule in Foss and Harbottle? And we look at section 5 of the Act, the new Act, under the old section 7. We said that rules of the common law and equity that apply to companies continue to apply so long as they are not inconsistent with the Companies Act. And I told you that in Saradec, that's the justification the court gave for the continued application of the Foss and Harbottle rule. And then I told you that, so the court then said that the Foss and Harbottle rule still applies, although it has been significantly watered down. And then I made an alternative argument to you that, in fact, if you look at all the exceptions that the court itself recognized to the rule in the Saradec case, and if you look at it in their proper context, in their full scope and effect within the meaning of the Act, the conclusion the court should have come to is that based on the inroads that have been made, the exceptions are so many and their effect is such that they have collapsed the foundations of the rule. So the rule should no longer be considered to exist because of the exceptions or the reforms or the inroads that the Act has made. Am I making sense?
Yes, sir. You're making a lot of
sense. Yes.
Yeah. Okay.
If I can come in here, Elvis here.
Yeah, Elvis.
Yeah, so if I understand you very well, what you are trying to say is that the Act 992 has done some modifications to the rule as espoused in the case of Foss versus Harbottle. So there was a recent case that was ruled by Justice Richmond, where the case of Kuburam Adam versus Sadiko Bahama Company Limited, where the justice made the case that the Ghanaian law has made modification to the rule in the Foss versus Harbottle case. So under the section 218 and 219 of Act 992, the individual members are vested with the right to sue a company. So if I understand your point, you are saying that unlike other provisions, maybe the Contract Act or whatever, there is also modification to the rules on Foss versus Harbottle per Act 992, and the provisions that you mentioned to us, section 29, 218, 219, and all that. Please, am I right?
That's what the discussion has been about.
Thank you, sir.
Any other question? Any other question? Okay, if there's no other question, then let me just conclude the class and let's go. So what we have been looking at in a nutshell is this, that within a company, just like in politics, even your student politics, I'm sure your LSU, I'm sure when you go to LSU meetings, there are people who hijack the meeting and who are aligned and all that and who want to impose certain decisions and all that. So it's human nature, it's everywhere, right? It's everywhere. So everywhere that you have humans coming together to do something, an association, a company, in parliament, wherever it is, you would have power play, right? You have power play. You have people who have a greater power. They want to exercise it in a manner that will favor their interests. They want to engage in transactions that will favor themselves, etc. And then you have people in the minority who will be kicking against and crying to the rooftops about these transactions or decisions that are being taken, etc. So what we have tried to look at is, how does the law try to mediate this issue of majority people in a company, shareholders and majority shareholders and the directors who normally control the affairs of the company, as against the minority in the company, usually minority shareholders and sometimes minority directors, because like sometimes the directors represent the minority shareholders and in the boardroom they are overruled all the time. So yeah, so you may have majority shareholders and the directors who are supporting them, and maybe the minority shareholders and the directors who are on their side. So you have this power play in the company, and then the board may take decisions that the minority considers to be unlawful or irregular or ultra-vires or simply maybe prejudicial, unfair, harsh, etc. How does the law mediate between these things? And we mentioned that under the English common law, the judges were, the law developed in a way that was a bit more neutral. They didn't want to interfere. So that's how the Foss and Harbottle rule developed, and said that, one, if there's an action, a wrong against the company is the proper plaintiff based on the Foss and Harbottle, based on the Solomon and Solomon rule, because the company is a separate legal entity and has to conduct its own business. So it has to be the directors who have to sue on behalf of the company. So the court will not entertain that. And number two, if the matter is one that can be remedied, then the members should deal with it, because why should we intervene on your behalf and cancel a contract the company has entered into, or cancel a resolution the company has entered into, has passed, only to discover that maybe majority of the members are in support of it, right? The court said, no, we shouldn't do that. If the majority of the members are in support of it, then let them do it. It's majority rule. We won't intervene. But then later on, the court realized, this may cause hardship. So let's develop exceptions. The court developed exceptions to that rule. So you have the ultra-vires rule, you have the special procedure rule, if the rules require that you pass a decision by a certain majority. You have the further and the minority exception. And then you have the personal rights of members, right to attend meetings, votes. So if those, your case falls within one of those exceptions, then the court under the common law will be willing to intervene. Then these rules, under our Companies Act, because the common law still applies, the court have said those rules apply, right? But then, if you look at the exceptions that have been created, or the inroads that have been made by the Act, enforcement of regulations by members, or the Constitution by members, actions to enforce illegal, irregular, and ultra-vires acts, remedies against oppression where a member can sue, or even an officer can sue if the affairs of the company are being conducted in a manner that's unfair, prejudicial, discriminatory, harsh, etc. And then also the powers of the registrar to conduct investigations into the company. Then you have directors' duties under section 190 to 199, and the right of members to sue, to enforce the director's duties, etc. So if you look at the combined effect of all these, all the numerous sections and all the numerous grounds on which either the member or even sometimes an officer, or even a third party who has powers, who has been given a right under the regulations, may be able to bring an action to challenge either a decision of the company, decision taken by the directors, enforce directors' duties, etc. If you look at all these effects holistically, I submit that the proper conclusion to reach is that in our corporate governance structure, this so-called Foss and Harbottle rules, proper plaintiff and majority rule, are not applicable if you look at the acts critically, and if the courts are really interpreting it, the law correctly. Then they should come to the conclusion that a member cannot be prevented from suing to challenge an action on the basis that they are not the proper plaintiff, or that merely because the action or decision or transaction has been taken is one that the company can remedy by itself, because the law does not condition a member's right to sue either the directors or to sue to enjoin the company from engaging in transaction or implementing a resolution on these grounds. It doesn't condition it on the ground that the company can remedy them. So then, if the company can remedy them, then no action will lie. That's not what the law says. So that has been my argument. But then the Supreme Court in Seredek and other cases thinks otherwise. So if you are looking for what the law is, that's what the Supreme Court has said. But for academic arguments, you may maybe come to my side. Thank you very much. In any case, the lights have been taken away, so I have no option than to end the class. So yeah, thank you for.
Thank you.
Oh, Chris. Thank you so much, Chris. Thank you, Chris. We are sorry about the electricity, and I think at this time it's even a bit late for you. You have to run home.
Yeah.
Thank you so much. You have done such a wonderful job, and I clearly see that my students have really enjoyed the lecture, and I'm grateful for you. I'm grateful to you, as always. So next week I'll find out from them by way of an assessment what happened in here, and then I'll give. Oh, the light is back.
Yeah. Nigeria carry last.
I know, right? You guys have redeemed yourself, but thank you so much. Thank you so much, Chris. I'm grateful as always for all your help. All right, so guys, let's say thank you to Dr. Ninevi, and then God willing, we'll meet him again. We'll be back again. Don't worry.
So much.
We'll be back again.
Thank
you so much, sir.
Thank
you.
Have a good night.
No, thank you so much.
Have a good night.
Good night, Chris. I'll call you after. Thank you.
Good night.
Bye.
Good night.